Madam President, I rise today to urge my colleagues to allow a debate on the DISCLOSE Act, a common-sense measure to fix just some of the problems created by the Citizens United decision. Madam President, for a century, Congress has done everything it could to make sure the American public had as much information possible about the money being spent in our elections. The first federal campaign finance disclosure law was passed in 1910, which scientists tell us was 100 years ago. It was strengthened in 1925. In the 1970s, it was replaced with an even stronger system as part of the Federal Election Campaigns Act. And just 8 years ago, in McCain-Feingold, it was strengthened yet again. So, the United States Congress has been in the disclosure business for 100 years. And in fact, at every major step, the Supreme Court has actually affirmed Congress's power to pass these laws. In 1934, the court unanimously upheld the disclosure laws that Congress had just passed a decade earlier. In 1975, they upheld the disclosure provisions of the Federal Elections Campaign Act. In 2003, they upheld the disclosure and disclaimer provisions of McCain-Feingold. And just this January, in Citizens United, yes, in Citizens United, they voted 8-1 to uphold those same disclosure provisions again. Madam President, the disclosure provisions of the DISCLOSE Act are well in line with a century's worth of federal statutes and precedent, at least according to the Burger Court, the Rehnquist Court, the Roberts Court, and the Hughes Court. I bet some of you haven't heard of the Hughes Court. That was from 1934. So we can pass this law. We can do it. And there should be a will to do it. Now, here are some excerpts from a few members' floor statements from the 107th Congress, the Congress that passed McCain-Feingold. Quote, "Clearly, the American public has a right to know who is paying for ads and who is attempting to influence elections. Sunshine is what the political system needs." Another member said, quote, "We can try to regulate ethical behavior by politicians, but the surest way to cleanse the system is to let the sunshine in." Here's yet another. "Disclosure helps everyone equally to know how their money is spent. Disclosure is what honesty and fairness in politics is all about. Why would anyone fight against disclosure?" Madam President, these are actually the statements of friends of mine across the aisle who are still in this body, who opposed McCain-Feingold and who opposed it in large part because they said it did not do enough on disclosure. In fact, a lot of them opposed it precisely because it did not do enough to promote disclosure of the independent expenditures of corporations and unions. As my good friend Senator Hatch said in March of 2001, "The issue is expenditures, 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 and the real issue, if we really want to do something about campaign finance reform, is disclosure, disclosure, disclosure." I think he repeated it 3 times for emphasis. This is what the minority leader said when he voted against the McCain-Feingold bill as amended by the House in March of 2002. This is the minority leader, Senator McCollum from Kentucky. Quote, "Reformers claim this bill will increase disclosure and shine the light on big money in politics. This, of course, is not true. Unions will continue to funnel hundreds of millions of dollars of hardworking union member dues into the political process without ever disclosing one red cent. Well, the protections that my friends were waiting for are in the DISCLOSE Act. And they boil down to this: if someone is spending a lot of money in our elections, American voters will have a right to know whether that person is a corporation, a nonprofit, a union, or a 527. Before I close, Madam President, I want to discuss a part of this bill that does not have to do with disclosure, Section 102. Section 102 incorporates critical provisions of the bill that I introduced in the American Elections Act. It will make sure that foreign interests, foreign governments, foreign corporations, and individuals can't use American subsidiaries that they own or control to influence our elections. The fact is, after Citizens United, the U.S. subsidiaries of foreign companies will be able to spend as much as they want in our elections, even if they are under foreign control.
The Senator's time has expired.
May I ask for another couple minutes, or
is there objection?
Madam President, reserving the right to object, I've just asked for another couple minutes to be added to our time. If that's okay with the Senator from Minnesota, I have no objection.
I thank
Without objection.
I thank the Senator from Texas. Fact is, after Citizens United, the U.S. subsidiaries of foreign companies will be able to spend as much as they want in our elections, even if they're under foreign control. President Obama alluded to this in the State of the Union, and Justice Stevens said it explicitly in his dissent. And more American companies are coming under foreign ownership and control. According to the congressional research, between 1998 and 2007, there was a 50% increase in the number of mergers and acquisitions where a foreign firm acquired a U.S. firm. But our laws are out of date. They don't protect against election spending by those foreign-controlled companies. There are basically only 3 restrictions on election spending by foreign companies. 1, you can't be headquartered or incorporated abroad, but the subsidiary can be, all it has to be is headquartered here, like BP America. You can't use your money that you've earned abroad in our elections. So, you can use money earned here. And you can't let foreign citizens decide how to spend that money, but the boards of these companies kind of know how Citgo, say, might want to spend its money. Here's one, that is one company, Capacitas, and spend unlimited amount of their money in our elections. Citgo, 100% owned by Hugo Chavez and the Venezuelan government. Here's another company, Capacitas, British Petroleum, or rather its subsidiary, British Petroleum American. This is unacceptable. The DISCLOSE Act updates our laws and says that if a foreign entity has a controlling stake in a company as defined by most states' corporate control standards, or if a foreign entity controls the board of directors of a company, that company should not spend one dime in our elections. I thank the Senator from Texas. I thank the Madam President, and yield my time.